8th, 2023. The committee will hereby come to order. We are conducting an executive session today on two of the most consequential bills in the entire legislative session, one related to police vehicle pursuits and the other related to the drug possession law and the response to the State versus Blake case. I will ask staff to actually, Corey is sick and is at home. I don't know if he's going to be participating remotely or okay. So I'll ask whoever's filling in. Let's see. Let's do the vehicular pursuits first, please, and then we'll do the next bill.
Martha Whaling, staff to the committee. Engrossed Senate Bill 5352 relates to vehicular pursuits. As a reminder, the companion bill, Substitute House Bill 1363, passed out of this committee on February 16th. As a brief background on 5352, it modifies the requirements for law enforcement to engage in vehicular pursuits by lowering the evidentiary threshold from probable cause to reasonable suspicion in order for an officer to engage in a pursuit. 5352 adds two categories of offenses when an officer may pursue: vehicular assault and assault in the first, second, third, and fourth degree involving domestic violence. 5352 modifies the balancing test for the risk of pursuit, changing it from an imminent threat of safety to a serious risk of harm. It requires notification to the supervisor by the officer when a pursuit is initiated, and it requires notification to other law enforcement agencies about the pursuit, and requires that the officer have the ability to communicate with other officers. 5352 requires a plan to end the pursuit through intervention options like spike strips, and it requires officers who pursue to participate in training. The two most significant differences between 1363 and 5352 are a change in the title. 5352 has a far more detailed and therefore narrow title, and the elimination of the sunset provision that was in 1363. There are 10 proposed amendments. So beginning with PAT 156, sponsored by Representative Graham. PAT 156 changes the basis to pursue from 6 different types of offenses to any criminal offense. Representative Goodman, do you want me to just go through all 10?
Yes, please.
Okay. PAT 157, sponsored by Representative Griffey, adds reckless driving to the offenses for which an officer can engage in pursuit. PAT 158, sponsored by Representative Graham, adds physical pain or injury or constraint or restraint to the offenses for which an officer can engage in pursuits. PAT 159, sponsored by Representative Griffey, adds theft of a motor vehicle to the offenses for which an officer can engage in pursuit. PAT 160, sponsored by Representative Griffey, adds nonviolent offenses that involve damage to or theft of property to the offenses for which an officer can engage in pursuit. PAT 175, sponsored by Representative Graham, adds the felony or arrest to the offenses, felony or an arrestable offense to the offenses for which an officer can engage in pursuit. PAT 161, sponsored by Representative Mosbrucker, makes 2 changes. First, it requires an officer to attempt to notify, rather than notify, a supervising officer when a pursuit is initiated. And second, it requires an officer in a jurisdiction with fewer than 10 officers to attempt to request, rather than to request, the on-call supervisor be notified of the pursuit. PAT 174, sponsored by Representative Mosbrucker, increases the number of officers in a jurisdiction from 10 to 15 for when the requirement for contacting an on-call supervisor in the event of a pursuit is required. PAT 177, sponsored by Representative Mosbrucker, requires training for officers that must include the risk assessment analysis when weighing the serious risk of harm against the safety risks of failing to apprehend in the event of a pursuit. And then finally, PAT 176, sponsored by Representative Griffey, changes the definition of a vehicular pursuit so that the definition requires a vehicle's siren to be activated to constitute a vehicular pursuit. And there are no other amendments in the EBB.
Okay, no other amendments? No, all right. Are there any questions? I'm sure there's plenty of questions, but okay, let's move on to the next bill, please.
Good afternoon, Chair Goodman, members of the committee, Michelle Rusk, staff to this committee. As a reminder, this committee held a public hearing on engrossed second substitute Senate Bill 5536. Broadly speaking, Senate Bill 5536 does the following three things: modifies regulations and prohibitions concerning certain drug possession offenses and related penalties, establishes judicial procedures concerning such charges and convictions, and modifies or establishes programs and services relating to substance use disorder treatment and recovery, which I may refer to as SUD. There's a proposed striking amendment in the EBB sponsored by Chair Goodman. There are also 12 proposed amendments to that striking amendment. I will brief the striking amendment, and then my colleague Lena Langer will brief the amendments. Striking Amendment H1740.1, offered by Chair Goodman, contains a very thorough effect statement providing a comprehensive overview of the changes in that striking amendment. I will provide a broader, more general overview of the categories of changes. First, the striker makes the following changes to the bill's criminal legal provisions. It reclassifies the offenses of possession of a controlled substance and possession of a counterfeit substance as misdemeanors rather than gross misdemeanors. It also provides that knowing possession and use of a controlled substance, counterfeit substance, or legend drug in a public place constitutes a misdemeanor subject to certain exceptions. The striking amendment applies its provisions concerning pretrial diversion and sentencing to charges and convictions of knowing possession and use of applicable substances. With respect to drug paraphernalia, the striker provides that the state occupies and preempts the field of drug paraphernalia regulation. Provisions related to pretrial diversions for certain drug offenses are modified. The modifications, again, are described in great detail in the effects statement, but at a high level, they include: the court may not grant a motion for pretrial diversion without the prosecuting attorney's consent, and there are modifications to when a court must or may grant a motion for pretrial diversion. The state must make resources available to assist defendants with scheduling rather than obtaining an SUD evaluation or expedited assessment. And the provision requiring courts to provide defendants with transportation assistance is removed. An SUD counseling agency rather than treatment program must make a written report to the court of its findings and recommendations, and there are modifications to how that report must be distributed, handled, and disclosed. A prosecuting attorney may only make a motion to terminate pretrial diversion when it appears the defendant is not meaningfully engaging in recommended treatment or services, and successful completion of pretrial diversion includes substantial engagement rather than compliance with assessment, recommended treatment, or services. Turning to the bill's sentencing provisions, as a high-level overview, the striking amendment does the following. It eliminates the 21-day mandatory minimum sentences for persons convicted of certain drug offenses who refuse an SUD assessment and recommended treatment or services as a condition of probation. It also eliminates the mandatory minimum sanctions the court must impose if it finds a person has willfully abandoned or demonstrated a consistent failure to meaningfully participate in treatment or services. The striking amendment also requires the state, instead of courts, to assist the defendant in scheduling rather than obtaining an SUD evaluation or expedited assessment, and removes the requirement the courts provide a defendant with transportation assistance. The striker also makes changes to the procedures regarding preparation of an SUD assessment, information that must be included in an SUD assessment, and the nature of treatment a court may require a defendant to complete based on an SUD assessment. It also requires meaningful engagement rather than compliance with treatment or services as a condition of probation, and provides that only a prosecuting attorney, not the court, may make a motion for a hearing to consider sanctions if a sentenced person is not meaningfully engaging in recommended treatment or services. With respect to vacation of convictions, if a person convicted of certain drug offenses successfully completes an SUD treatment or services program and files proof of completion with the court, the prosecutor must make a motion to vacate that person's conviction, and the court must grant the motion upon verifying successful completion. A new requirement is added directing the Administrative Office of the Courts to collect and report on data regarding the utilization and outcomes of specific forms of pretrial diversion, sentencing, and post-conviction relief for certain drug offenses. Other changes are made, including eliminating the requirement for the Department of Health to hold a public hearing before making a decision on an application for licensing or certifying an opioid treatment program. The provision creating a right to court-appointed counsel for certain parenting plan or child custody proceedings is eliminated. With respect to appropriations, specific appropriations made within the bill are removed and instead made subject to appropriated funds. And finally, an effective date of July 1, 2023 is provided for mandatory provisions relating to certain drug offenses and also the data collection and reporting requirement for the administrative offices of the court.
Thanks. Lena Langer, staff to the committee. As Michelle mentioned, there are 12 amendments proposed to the proposed striking amendment. The first is PAT 162. This is offered by Representative Griffey. The amendment reclassifies knowing possession of a controlled or counterfeit substance and knowing possession and use of such substance in a public place as gross misdemeanor offenses. The amendment also provides that a person who is convicted of knowing possession of a controlled or counterfeit substance or knowing possession and use of such substance in a public place must be sentenced to a term of confinement of up to 364 days, all of which must be suspended for a period not to exceed 2 years. Second is PAT 163. This is offered by Representative Graham. This amendment appropriates $1,205,000 from the State General Fund to the Washington State Patrol for the analysis of evidence for suspected violations of certain drug offenses. Third is PAT 170, offered by Representative Mosbrucker. The amendment requires the Department of Commerce, subject to availability of funds, to administer a substance abuse prevention grant program for the purpose of awarding grants to local law enforcement agencies to establish or expand peace officer-led educational programs. Fourth is PAT 179, offered by Representative Griffey. The amendment requires the court, when necessary and to the extent possible, to provide a defendant with a list of available resources to assist the defendant with securing transportation to a substance use disorder evaluation as a part of pre-trial diversion or an agreed term of probation for certain drug offenses. Fifth is PAT 164, offered by Representative Mosbrucker. The amendment provides that successful completion of pre-trial diversion for certain drug offenses includes completion of recommended treatment or services as indicated by a certificate of completion rather than meaningful engagement with assessment, recommended treatment, or services. Sixth is PAT 165, offered by Representative Graham. This amendment requires courts of limited jurisdiction to impose a minimum term of imprisonment of 21 days when sentencing persons convicted of certain drug offenses who refuse to submit to a substance use disorder assessment and comply with recommended treatment as a condition of probation. Seventh is PAT 167, offered by Representative Mosbrucker. This amendment requires that when a person has a court-directed service plan, the service provider must provide updates to the court at least monthly, rather than no more frequently than monthly, on the person's progress with recommended treatment. Eighth is PAT 166, offered by Representative Graham. This amendment requires the court to reinstate a minimum portion of a person's suspended sentence if it determines that the person has willfully abandoned or demonstrated a consistent failure to meaningfully participate in recommended treatment or services, depending on how many times the person has been sanctioned. Ninth is PAT 172, offered by Representative Graham. This amendment requires the Administrative Office of the Courts, or AOC, to collect data and report annually on the recidivism rate for persons who participate in pretrial diversion or agree to obtain a substance use disorder assessment and participate in recommended treatment or services as a condition of probation for certain drug offenses. 10th is PAT 173, offered by Representative Griffey. This amendment requires the AOC, in cooperation with Washington State Patrol and the Washington Association of Sheriffs and Police Chiefs, to collect data and information related to reported violations of certain drug offenses responded to by law enforcement. The amendment also requires the AOC to include this data and information in an annual report to the legislature. 11th is PAT 168, offered by Representative Mosbrucker. This amendment restores the provision in current law requiring the Department of Health to hold a public hearing in the affected community before making a decision on an application for licensing or certifying an opioid treatment program. Finally, there's PAT 169, offered by Representative Mosbrucker. This amendment appropriates $49,017,000 from the State General Fund and $4.3 million from the Federal General Fund to the Healthcare Authority related to funding for opioid use disorder medication, Department of Health certified clubhouses, 23-hour crisis relief centers, certain community grants, and law enforcement assisted diversion programs. And those are all the amendments available in the EBB.
Thank you very much. Thank you very much, actually, to all of you. It's a lot of work and very, very well done summarizing everything. We will now recede to our respective caucuses and reconvene. I don't know. How do you think we can do it? All right, we'll try to get back here at 4 o'clock. I'm sorry, 5 o'clock. That'll give us an hour, but let's endeavor, let's aim, let's encourage to get back into the room here at meaningful engagement. We will now engage in meaningful engagement. So we'll be back at 5 o'clock if we possibly can. The committee is in recess now. All right, we are now back in session. The committee is going to take up in executive session the 2 bills on our agenda. And we will begin with the bill related to police vehicular pursuits. Madam Vice Chair.
Mr. Chair, I move that engrossed Senate Bill 5352 be reported out of committee with a due pass recommendation. Second. Dan.
It's been moved and seconded that engrossed Senate Bill 5352 be reported out with a due pass recommendation. There are a number of amendments. I'll ask the ranking member if you could if you are willing to withdraw a number of amendments.
Thank you, Mr. Chair. We will be withdrawing PAT 156, PAT 157, PAT 158, PAT 159, and 160 PAT, and then PAT 175 for scope issues.
So amendment PAT 156, 157, 158, 159, 160, and 175 have been withdrawn. The next amendment is from the ranking member, PAT 161. The chair recognizes the ranking member to move adoption.
Thank you, Mr. Chair. I'd like to move PAT 161 amendment, please.
It's been, the member has moved adoption of amendment PAT 161. Chair recognizes the ranking member.
Thank you very much, Mr. Chair. And the concern with this amendment is that we've heard repeatedly that I live in rural Washington. I get to live in the country in my life. And it is very difficult and often impossible to reach back into an area to let someone know that you would like to pursue or to continue a pursuit. So what this simply says is that may we please just be able to notify, because sometimes we can't even reach a 911 dispatch, right? But it would show on the law enforcement officer's phone that he had attempted. So we're hoping for passage of this. We want to make sure that often in small areas, this amendment also makes sure that in small departments, sometimes the supervisor is the law enforcement officer who's got the issue, right, in the field, and he would call himself. How would that work, right? So we're hoping for a yes on this amendment to help with this clarity and help out rural Washington.
Thank you. I agree with the intent here. The wording, however, is a little awkward, attempting to notify. And I think when we consider the amendment right after this, we will probably be able to solve this problem. The current law requires that the officer notify a supervisor that the pursuit has begun, but there's actually no requirement that there be any return, like acknowledgement of notification. And so I'm going to ask that we not adopt this amendment just because the notification is already happening. We don't have to attempt to notify. Chair recognizes the ranking member.
Thank you very much, Mr. Chair. I think, is this something that we can ask staff? I think your understanding of what the amendment or what it says in the language of this bill is different than mine. So can we clarify with staff? Do you mind?
Sure. Yeah.
Martha Whaling, sorry, thanks for giving me some time to get to that particular amendment. So we are looking at Amendment 161, Pat 161.
Yes.
So the current language in the bill is notifies, and the language that is proposed is attempts to notify. There is also language added, if applicable, to qualify those requests and attempted requests. Does that answer the question, or was there a different question?
Yeah, I think the question was, is notification is the requirement, but there's nothing further than that, the person attempting, the person to be notified doesn't need to acknowledge the notification. So I think it works as it's written, where the officer gets on the horn and notifies, and then, yeah, sure, Ranking Member?
Thank you, Mr. Chair, and thank you, Martha, so much for looking that up. Sorry we didn't give you notice. This just came up. So if I'm in the field, I'm a law enforcement officer, and I attempt to call back to dispatch, which could be clear across Clickitat County or Yakima County from one side to the other without service or radio service or dispatch in any way with towers. If I attempt to call in regarding the potential vehicular pursuit, does this bill cover that? Or do they actually have to be a notification where someone answers the other side of that call, whether it's dispatch or the law enforcement agency themselves? I think that's what we're trying to figure out.
So regarding notification, the bill is silent on the response, like Representative Goodman indicated. However, the language in the bill does require supervisory oversight of the pursuit. So that indicates that there would need to be an individual on the other side of the phone.
Yeah, and that's the next step, which the next amendment addresses, because we do want to provide accommodation for those small police agencies. So I am going to ask for, because we have to move along here, I'm going to ask for, we not adopt this amendment. All those in favor of adopting Amendment Pat 161, please say aye. Aye. And any opposed? Nay. In the opinion of the chair, the noes have it, and the amendment is not adopted. The next amendment is Amendment 174. The chair recognizes the ranking member.
Thank you very much, Mr. Chair. And I think that this is addressing part of what we talked about in the previous amendment, where making sure that in some jurisdictions, we often craft laws in Washington state that have to do with large law enforcement agencies, and we forget that there's many that are smaller and don't have the resources they don't have the resources, or they don't have the manpower to cover what we're asking them to do. So this simply moves the number from to the 10 and the 15
Yes,
switches.
I strongly agree. I believe we should adopt this amendment. We've heard from a number of police agencies that are between 10 and 15 officers, and so they're not covered. And this is the difficulty we've just discussed about finding someone on the other end, even though you've notified, and also supervisory oversight. So I strongly support this amendment. All those in favor of adopting Amendment 174, please say aye. Aye. Any opposed? The amendment is adopted. Next, Amendment 177. Chair recognizes the ranking member.
Thank you very much, Mr. Chair. I'd like to move Pat 177, please.
It's been moved that we adopt Amendment Pat 177. The chair recognizes the ranking member.
Thank you, Mr. Chair. This has to do with the fact that we want to be sure that there's adequate training for law enforcement officers to, before they decide whether to pursue or not, that they do this self-balance test. And the balance test says, is it safer for me to pursue that offender, or is it safer for me to not pursue that offender? Many of us think that we're already doing that in Washington state, but we want to be sure, we want to make sure the officers are trained on that to make that decision. And so I ask for a yes on this amendment.
Excellent amendment. Very strongly supporting it. Chair recognizes the Representative Ramos.
Thank you, Chair Goodman. We absolutely agree. They should be trained to what they're doing, and they should always be able to make an assessment in the field, what's safe and what's not, and we agree.
This reinforces what we want is for the, to make sure that the pursuit itself is not more dangerous than the risk of not apprehending the individual. All those in favor of adopting Amendment 177, please say aye. Aye. Any opposed? The amendment is adopted. The next amendment, 176, the chair recognizes Representative Griffey.
Yeah, thank you, Mr. Chair. I move 176.
It's been moved that we adopt Amendment 176. Chair recognizes Representative Griffey.
Thank you, Mr. Chair. This modifies the definition of pursuit in those times where the law enforcement officers turn on their lights, that they're not actually engaging in a pursuit. It's not until they turn on their lights and siren. So the turning on the lights, they're notifying the individual that they're trying to pull them over. We don't want law enforcement to be caught up in that because we've asked them to enforce the law. We've asked them to look after problems with vehicles and that sort of thing. And that's how law enforcement initially tries to pull them over. I urge its adoption.
Thank you. Asking that we not adopt this amendment because this would allow police to pursue without using a siren at high speeds. If the siren is the decision, is the what constitutes a pursuit, there's a lot more to it than that. So I would ask that we not adopt this amendment because the high-speed pursuit could nevertheless ensue even without a siren. All those in favor of adopting Amendment 176, please say aye. Aye. And those opposed? Nay. The noes have it. The amendment is not adopted. And that is it now. Okay, we have before us engrossed Senate Bill 5352 as amended. Is that correct? Okay. And we will ask for comments on final passage. The chair recognizes Representative Farivar.
Thank you, Mr. Chair. While I certainly appreciate that this legislation has been narrowed from where it starts, I am still going to be a no today. And I think that's the right thing to do here. You know, I continue to hear from my constituents and from advocates who have deep concern about moving forward this legislation. And I'm really concerned about the lives that are currently being lost, that will be lost from this, both the subject of pursuits, bystanders, passengers, and law enforcement as well, who are losing their lives. You know, right now in my district, there are 4 active investigations for 4 fatal pursuits that have happened, 2 non-fatal pursuits. So there's real harm happening in our communities as a result of this. I really think that we struck the right balance when we passed 1051 not too long ago. The law hasn't been implemented for enough time for us to really have enough information to go forward and change it. You know, the information that we do have indicates that the law is working so far in terms of folks not losing their lives. We don't have data that supports us moving forward to expand pursuits. And I think that we have to take that really seriously. I also worry mostly that this is an implementation error, a challenge in our understanding of the law, not necessarily the law that is preventing law enforcement from pursuing individuals. And I worry at the end of the day that we may be choosing politics over people. And I know all of us take our responsibilities here very seriously, but it does weigh heavy on me, the decisions that we're making right now and in the next legislation that we're considering today. And I just want to make sure that we're centering the voices of folks who have lost their lives and who will be harmed by this policy. So I'm going to be voting no today. Thank you.
Thank you. We're actually going to take a step back because we made a procedural error. We didn't roll this into a striker yet. So thank you for your speech on final passage. We'll remember it, but I'll ask the Vice Chair to make the necessary motion. Please go ahead.
Thank you, Mr. Chair. I move that the adopted amendments be incorporated into a striking amendment and that engrossed Senate Bill 5352 be reported out of committee with a do pass as amended recommendation.
Okay, so now we have before us the striker, and we'll just imagine that you just gave that terrific speech. I will encourage passage of this striker. I believe it's a not unreasonable proposal to limit police vehicle pursuits to the most serious crimes. Those crimes that don't involve injury to person can be solved in other manners, particularly with technology such as the adhesive GPS device and drones and so forth. So we really want to attend to those crimes where people are grievously injured and killed, but nothing more than that. Chair recognizes the ranking member.
Thank you very much, Mr. Chair, and thank you for your beautiful speech. I hear you, and I know that I'm really grateful that all of us have been working together on this for a while, and hopefully we'll continue to work on it, because I think you're going to see a mixed vote on our side for lots of different reasons. I think some of us, we had in 21, we had a series of reform bills, and for most of us, this was the last piece of the puzzle in order to protect the community as well as protect law enforcement. We would argue that there's a balance test, right? I mean, I think all of us decide the consequences of what we're going to do or what we're not going to do every day in many situations. And many of us feel like law enforcement is doing that, and they have a very difficult job. Again, they run into danger when we run away and hide. And we have to remember that, because this is a very unique career, a very unique situation where their lives are at risk every day. I think that we have heard tragic stories of families who've lost loved ones, that you could find a nexus between this vehicular pursuit bill and those incidents. And I think that this warrants a lot of discussion. We don't want someone harmed during a pursuit, and we don't want people harmed because of a pursuit. We want to make sure that we find that balance. So I'm appreciative of the conversation that I'm sure will be ongoing. We can do better than this. Right? I think that what we have out there is a product, even this, that isn't good enough for the people of Washington State. And we'll move it today, hopefully, and we'll continue the discussion throughout the end of session, and then hopefully through interim, by trying to gather more data and trying to talk and hear each other, not just listen, but actually hear what we say. So I am going to be yes today, but I understand completely the work that has to be done on this, and I fully understand a no vote as well.
Thank you. Well, let's have a roll call vote on this. Oh, okay. Chair recognizes Representative Graham.
Thank you, Chair. Wow. There's so many things going through my head right now. I definitely hear the concern when it comes to pursuits that happen in which somebody is killed. That is absolutely horrific that happens. And you're right, it shouldn't be happening. I have heard, though, from constituents in my district that there is frustration with the fact that when the police are attempting to pull them over, they have a choice on whether to stop or to speed up. And it is absolutely unacceptable that they don't stop, that they do decide to speed up. And unfortunately, that there have been people that have been killed in the police pursuits, but it's equally and just as important to point out how many cases we are seeing in the news every day, it seems like, where there is somebody, we've had children that have been killed because the police were not able to pursue. It is outrageous at this point that our police could not pursue somebody that's driving 111 miles an hour down the road. That should be reckless driving. There should be no question as to whether they could pursue. If they're driving the wrong way down the highway, it is outrageous that they would not be able to try to stop that person from killing or injuring people, which we are seeing, happening and increasing. Because we have individuals like what is happening in Spokane right now, where we can have police officers driving down the road and have somebody come up next to them and tease the police, rev their engines, and drive off, and the police can't do anything about it. I am speaking up for the children that are dead at this point in time, because we passed bad policy and we're ignoring those families. We're ignoring those children that are killed. You know, and again, it's not like we don't have another option to be able to say, if the police put on the lights to pull you over and you do not pull over, they should be able to pursue. And not only that, I think we're failing as far as not throwing the book at them. You don't want to pull over, you put everybody in jeopardy. That is anybody that might be in the car with you, that's police, that's bystanders. So it makes zero sense to me that we would not be going that direction where we hold the person accountable that makes the choice to just do what it is they want. And this is also not taking into consideration how many people we are seeing again on a daily basis that are getting their cars damaged, and the police can see it and they can't do anything to stop it. There are families out there that are they are on fixed incomes. They're young people starting out. They're disabled people that, you know, are trying to be able to get back and forth to work. They don't have the money or the resources to just buy another car. And that is something that, again, we should be taking into consideration. And lastly with this, again, I'm going to point to how many times I have heard that we are changing our justice system to be more like Norway, and this is without a vote of the people, which I'm going to point out. But I will also point out that I have articles where they do allow police pursuit in Norway. And, you know, if they don't allow people to do what is happening here in Washington state. They stop them and they do hold them accountable. So if we're going to be doing what Norway does, then I don't think it's fair that we're just kind of picking and choosing, well, we want this outcome, but we're not willing to do the other things that it takes to get to that outcome. So I will be voting no today. We need to do better. I want to save lives on both sides of this, but honestly, the way we do it is you start holding the people accountable that are not following our laws, not following our rules, are putting people in danger, and if they do indeed hurt somebody, they should be getting more time, not less.
Okay, thank you for your remarks. If the staff could pull up the Standing Committee report, and we will have a roll call vote on this. And please call the roll.
Goodman.
Representative Goodman votes aye.
Rep. Goodman votes aye. Simmons.
Aye.
Rep. Simmons votes aye. Mosbrucker.
Mosbrucker votes aye.
Rep. Mosbrucker votes aye. Griffey. Rep. Griffey votes aye. Davis.
Aye.
Rep. Davis votes aye. Farivar.
Farivar, nay, do not pass.
Rep. Farivar votes nay, do not pass. Fossey.
Fossey, aye.
Rep. Fossey votes aye. Graham.
Nay without recommendation.
Rep. Graham votes nay without recommendation. Ramos.
Aye.
Rep. Ramos votes aye.
Thank you for your votes. Do any members wish to change or adjust your votes? Seeing none, will the clerk please report the record?
Mr. Chair, there are 7 aye, 2 nay, 0 excused.
Thank you. By your vote, the committee reports out engrossed. Oops, that's the wrong bill. Sorry about that. By your vote, the committee reports out engrossed Senate Bill 5352 with a do pass as amended recommendation. Madam Vice Chair.
Thank you, Mr. Chair. I move that